Special Counsel Jack Smith is urging federal judge Tanya Chutkan to reinstate a gag order against the disgraced, twice impeached, 4 times indicted ex-president Donald Trump. That's after he posted on social media appearing to openly intimidate his former chief of staff, Mark Meadows. Judge Chutkan had imposed a narrow gag order earlier this month in the election interference case, but she put it on hold last week while she considered an appeal from Trump. The ex-president immediately seized on that pause, seeing it as an opportunity to post about Mark Meadows on Truth Social, shown here as evidence in a new court filing by Smith's team. The filing reads, quote, "The defendant has returned to the very sort of targeting that the order prohibits, including attempting to intimidate and influence foreseeable witnesses and commenting on the substance of their testimony." Quote, "For example, on October 24th, 2023, the defendant took to social media to respond to a news report claiming that his former chief of staff, identified in the indictment, had testified in exchange for a grant of immunity. The defendant does not need to explicitly incite harassment or violence in his public statements because he well knows that by publicly targeting perceived adversaries with inflammatory language, he can maintain a plausible deniability while ensuring the desired results. The defendant knows the effect of his targeting and seeks to use it to his strategic advantage, while simultaneously disclaiming any responsibility for the very acts he causes." Wow. Let's bring into our coverage former Assistant U.S. Attorney, now an MSNBC legal analyst, Glenn Kirshner is back with us, and First Amendment scholar and professor at the University of Utah Law School, Ronell Anderson-Jones. Glenn, let me come to you first on what is perhaps one of the most striking contrasts between Special Counsel Jack Smith's paper, the things he produces in filings, and if you look just to the Mueller period. These filings are rooted in moment-to-moment changes in the landscape where they revolve around threats of violence. And I wonder if you can speak to two things. One, does that intersect with the same federal government's assessments of the current threat environment and their intersectionality with grievances about the 2020 election and the 2024 election and Trump's trials? And are they amplified by real concerns about witness tampering?
Yeah, I think, Jack Smith has been very forward-leaning, very direct. I wouldn't say hyperbolic, but he has pulled no punches in his court filings. And I was kind of happy to see that when you get about 10 or 11 pages into this most recent filing where he is arguing hard in favor of why Judge Chutkan should lift the temporary stay that she put in place, because, of course, the moment she put that stay in place, Donald Trump began to violate the gag order that, yes, had been stayed in sort of 2 of the 3 ways he had been gagged. He had been prohibited from speaking. And if I could read just one sentence,
please,
Nicole, on page 11, where Jack Smith really pulls it all together and highlights why Donald Trump is different than literally every other defendant. The special counsel's team writes, "There has never been a criminal case in which a court has granted a defendant an unfettered right to try his case in the media, malign the judge as a fraud and a hack, attack the prosecutor as a deranged thug, and after promising witnesses and others, if you go after me, I'm coming after you, target specific witnesses with attacks on their character and credibility, even suggesting that one witness's actions warrant the punishment of death." That is powerful. It's accurate. I think it sings as far as legal pleadings go. And, this, I think, demonstrates why Donald Trump is such a danger and not only needs to be gagged, but when you plow through 30 pages of this pleading on page 31, you finally see the mention of the potential of revocation of release and pretrial detention. So, Jack Smith is not pulling any punches.
That means jail.
That means jail pending trial.
So Jack Smith follows, I guess, Chris Christie and Judge Engoron, who've also been increasingly talking about the possibility that Donald Trump, the former president of the United States, spends time in jail, which, even someone steeped in all of the illegal conduct going back to the SDNY campaign finance cases that weren't charged, where he was individual one, is an extraordinary moment. And I wonder, does it seem, Ronelle, like it's what he's trying to have happen based on just an objective analysis of his conduct?
Well, I think that that assertion is really the centerpiece of the tensions that we see in both spaces, in both the filing that the DOJ has just made and in the enforcement issues that both of these judges are trying to straddle when they're thinking about how far they will go in bringing about the enforcement measures that are at their fingertips. And I think a big piece of this is this question of plausible deniability that we have been seeing threaded through both sets of issues. The DOJ's most recent filing certainly leans heavily into this question of plausible deniability. The language that you read about his awareness of the power of his audience and the way in which court personnel and witnesses can be made to feel targeted while he disclaims responsibility for that targeting. But that plausible deniability is also a really strong undercurrent in the enforcement end of these two gag orders and ties into the question that you've just asked. Technically, Donald Trump hasn't violated either of those orders. Instead, he dances at the very absolute edge of all of them. In the D.C. case, he, of course, wasn't subject to the order during the time that he made all of these most recent statements because the judge paused them to give some thought to what needed to happen while the question was on appeal. And he took advantage of that to amp up the kind of rhetoric that the judge had said was particularly dangerous to the integrity of the proceeding and to its participants. In the New York situation, when the judge chastised the defendant for continuing his attacks on the law clerk on his campaign website and then repeating them to the press, he argued that the first of these was inadvertent and that the second of these was a reference to somebody else. So we're seeing this theme of walking this line with plausible deniability and really a big game of chicken that is going on here. In First Amendment doctrinal terms, we really do care a lot about the precision and the narrowness of these orders. We're very nervous about overbreadth and vagueness, but you can see how this increases the incentives for someone who's inclined to weaponize plausible deniability, and that's the circumstance that we see coming to the forefront here.
I mean, I think that Glenn Kirshner, over the last 8 years, some parties have been reluctant to amass the facts as we can all see them with our own eyes and ears. And Jack Smith does not fall down at that task the way so many of the rest of us do. Let me read this from the filing. It's something that we covered here, but it's extraordinary to read here in this filing. Quote, see the example of United States versus Taranto after, quote, former President Trump posted what he claimed was the address of former President Barack Obama on Truth Social. Taranto, who had previously entered the Capitol on January 6, 2021, reposted the address along with a separate post stating, quote, see you in hell, Podestas and Obamas, and then proceeded heavily armed to the area the defendant had identified as President Obama's address, while live streaming himself talking about, quote, getting a shot and an angle. Trump's followers take him literally. Political violence has ensued. We live in a post-January 6th America, not a what if. They take him literally. They do, they did, and they continue to represent that threat. So says Jack Smith in his filing. Glenn.
You know, Nicole, I would argue that the institutions of government are proving themselves ill-equipped or perhaps not up to the task of treating the sort of ultimate ruling class criminal, a former president of the United States who tried to install himself in the Oval Office over the will of the American voters as a dictator. He tried to bring an end to the American experiment. It doesn't feel like the court system or the institutions of government writ large are meeting the urgency of the moment. And, you know, when I was sitting in court when the gag order was originally being argued, and I heard Judge Chutkan say the following: if it were any other defendant who was on release pending trial in a felony federal case who accused the prosecutor who was handling his case of being a deranged thug, that person would be in pretrial detention. You know, Nicole, one, that is indisputably true. And two, it is so disheartening because it is an express recognition that we're treating Donald Trump differently than, and here's the real injustice of it, the tens of thousands of other pretrial detainees all across this country who are sitting in jail cells awaiting trial because a judge has determined by clear and convincing evidence that they are either a flight risk or a danger to the community. I would hazard a guess that not a single one of them is as dangerous to the community or to society or to our democracy as is Donald Trump. But the system is, for whatever reason, declining to meet the moment.